This is the second video for your finals. We are done with the essential requisites of the contract. What are those? Always remember COC, consent, object, and cause or consideration. Now let us move on to the characteristics of a contract. We have autonomy, mutuality, obligatoriness and consensuality, and relativity. And these characteristics are provided for under Article 1306, 1308, 1315, and 1311 respectively. Let us start with autonomy. The contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. What does autonomy mean? This means that the contracting parties or those people involved in a contract are allowed to stipulate whatever they want with regards to the consideration and object and cause of their contract. So, tanan ninyong gusto nga i-appeal diha sa kontrata pwede. Unsa sa law, provided that they are not contrary to law, morals, good customs, public order, or public policy. So, let us take a look at this example. A and B entered into a contract. So, kinsay party na to? Si A and si B. It was agreed that A will give B 500,000 pesos if B will steal the pet lion of C. It was also agreed that A will give an advance payment of 250,000 and the balance will be given to B when B delivers the lion to A. As agreed upon, B stole the lion from the residence of C. Meaning in this contract, A and B agreed into doing something. A and B are the parties to a contract and they are free to stipulate clauses, terms, and conditions as they may deem convenient. Pwede sila mubuhat o kontrata because one of the characteristics of a contract is autonomy. However, B was apprehended by the police authorities before he could deliver the lion to A. Question: since B failed to deliver the lion to A as agreed upon, can A file an action in court against B for the recovery of 250,000 advance to B? Nganong inani man ang question, ma'am, nga autonomy man ta? Ibig sabihin, A and B, the parties to the contract, can enter into any agreement within that contract. Unsa ingon sa law, provided it is not contrary to law, morals, good customs, public order, or public policy. Karon kay ang ilang kontrata pagpangawat man, ug si B nasakpan sa mga pulis. Wala na deliver ni B ngadto kang A ang layon, pero si B nakahatag og 250,000 advance payment to B. Pwede ba nga mag-file si A sa court, mag-file ko B, pato ko court, kay kuhaon ako tong 250,000 akong gihatag sa imuha. Pwede ba? Can A file an action in court against B for the recovery of the 250,000 advance payment? The answer is no. The representation of B in the parties' contract is to steal the lion of C. Stealing is unlawful, of course, bawal mangawat. Hence, the contract is illegal and cannot be given effect. Even if si A and B na ay autonomy to enter into a contract, ginalimitahan na sa law, ibig sabihin, ang inyong kontrata must not be against law, morals, good customs, public order, or public policy. If A files an action for recovery of the 250,000 from B on the basis of their contract, both of them will be put on trial for the crime of robbery or theft. Let us now go to mutuality of contracts. This is provided for in Article 1308 of the New Civil Code. Unsay buot pasabot, the contract must bind both contracting parties. Its validity or compliance cannot be left with the will of one of them. Unsay pasabot, kung si A ug B nagsabot, sila ra pong duha ang pwede magdemandahay, dili pwede mo appeal og laing tao. Og ang fulfillment sa obligation cannot be left only to the will of one of them. Contracts bind both contracting parties and its validity or compliance cannot be left to the will of one of them. For example, ningon si A, B, palitan niya akong ballpen 500 pesos, paninglon ti ka ugma ha. Pag ugma ningon si A, B, ang binambayad sa ballpen, kay di ba paliton man nimo ni, is the contract valid? Of course, no. Nganong dili, wala man ni agree si B. Therefore, there is no mutuality of contracts. A contract containing a provision whose efficacy is dependent solely on the will of one of the parties is void. Diri ang nagbuot-buot kay si A raman, wala ni agree si B, therefore ang ilang kontrata is void. Termination, however, does not require mutuality and it can even be left to the will of one of the parties. Unsay pasabot? Kung mingon si A, B, palitan ni ako ang ballpen worth 500 pesos. Ingon si B, sige, paliton na nako na. What if the next day niingon si B ay di na lang nato ni dayunon? Ang dili pagdayon sa kontrata, dili kinahanglan nga mag-agree silang duha. Termination, however, does not require mutuality and it can even be left to one party by agreement. Kini, unilateral increase of interest rate is violative of mutuality of contracts even if the loan agreement between creditor and debtor gave the creditor a license to increase the interest rate. For example, nangutang ka, didto sa inyong kontrata na ay nakaingon nga ang interest sa imong utang is 5%. Niingon po ang kontrata. Pero ang creditor ko pwede daw mag-increase sa iyahang interest. Now, the next day, si creditor nag-increase. Instead na 5%, gihimo niyang 8%. Nabay karapatan si creditor mag-increase sa interest? Yes, na siya karapatan. Pero dili pwede nga si creditor magbuot-buot kung pila ang interest rate. Dapat ni-agree pud ka nga from 5% ang interest gihimo na karong 8%. Unilateral increase of interest rate is violative. Kung isa lang ang ni-decide, unilateral, dili mutual, isa lang. Dili siya pwede. Violative na siya of mutuality of contracts. Masking pag nagaingon ang inyong loan agreement nga pwede mag-increase. Tinuod, pwede mag-increase, but it must be agreed upon by the parties. So this is our first question. Remember this, ha? Can S compel B to accept the delivery of the car and to pay the purchase price of 3.5 million? Muna ang question, but let us take a look at the facts of the case. This is an example of the principle of mutuality of contracts. S promised to sell his car to B, an interested buyer. It was agreed nga kinsa daw, si S will determine the price of the car and inform B about it on the same day that S will deliver the car. The following day, S went to the house of B and delivered the car. S was also collecting from B the purchase price of 3.5 million, which is what S had decided. So, si S na isakyanan, kinsa ang nag-decide na 3.5 million daw ang presyo sa iyang sakyanan? Si S lang. Ni-agree ba si B? Let us go to the question. Can S compel B to accept the delivery of the car and to pay the purchase price of 3.5 million? The answer is no. There is no valid contract here. A contract is a meeting of the minds and therefore, there must be mutual consent. The contract does not bind both contracting parties because the determination of the purchase price of the car was left to the sole determination of S. Of course, if B decides to accept delivery and agrees to the purchase price of 3.5 million, syempre naanay kontrata. The contract of sale is perfected. Pero sa situation nato, kinsa ra ang nag-decide sa presyo? Si S. Wala man lang siya nangutana kang B kung uyon ba siya, pero gi-deliver gihapon niya ang car. Of course, there is no valid contract. Ngano gani, walay mutual consent between the parties. Let us now go to the third characteristic of a contract, obligatoriness and consensuality. This is provided for in Article 1315 of the new Civil Code. Obligatoriness or force of contracts. Under Article 1356, unsa ganin niyang ginaingon, maskim pa daw wala kay gipirmahan basta kay naa moy meeting of the minds, automatic the contract is valid, most especially if naay consent, object, and cause. 1356 provides that contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for its validity are present. So, kini siya, na ay consent, na ay object, and na ay cause. S agreed to sell his BMW car to B for 6 million, na ay object ang car, na ay cause 6 million, na abay consent, yes, nagkasinabot silang duha. 1315, Article 1315 provides that parties are bound from the moment contracts are perfected by mere consent. There is consent S agreed to sell his BMW car to B for 6 million. Both parties agree as to the object and the cost of the sale. 13.15, unsay ginaingon, parties are bound from the moment contracts are perfected by mere consent, not only from the fulfillment up to the consequences, which must be in keeping with good faith under Article 1159. Unsay ingon, pag ingon pa lang ni S nga ibaligyan ako sa imuha B ang akong sakyanan worth 6 million, sugod sa sinugdanan hangtod sa delivery, the consequences of that contract must be done in good faith. Nga naman, requisites before a contract is considered obligatory. It must be perfected, valid, and enforceable, provided that from the beginning until the end, you must be in keeping with good faith. For example, S agreed to sell his horse to B. It was stipulated that S should deliver the horse after 2 days. So for example, si S ug si B nagsabot pagka-Lunes nga paliton ni B ang kabayo ni S. Lunes na siya. Kano sa daw i-deliver? Wednesday. In this case, S has the obligation to deliver the horse after 2 days as agreed upon in the contract. Gipalit sa Lunes, i-deliver kuno sa Miyerkules. While waiting, wala man gud gibutang sa kontrata nga ang kabayo pakanon, ang kabayo ibutang sa shelter. Kailang gisabutan, paliton sa Lunes, i-deliver sa Wednesday. While waiting, since it was not part of the contract, S did not feed the horse anymore. Also, since it was not part of the agreement, S did not let the horse stay in the stable anymore. Gipasagdan na niya, gipaunglan-ulanan ang kabayo. Kay tungod, wa man dito sa kontrata ng alagaan ako ning kabayuan, ni gipalit naman ni atong Lunes. After 2 days, the horse fell ill and died. The veterinarian said that the horse catched a deadly virus while soaked in heavy rains 2 nights before the delivery date. Question: was S obliged to feed the horse and provide adequate shelter for it, considering nga wala man gingon sa kontrata nga alagain ng kabayo kung mag-ulan ipasilong, wala man na sa kontrata, obliged ba si S nga alagaan ng kabayo? The answer is yes. Pending delivery of the object of a contract, the debtor is obliged to take care of the thing to be delivered with the proper diligence of a good father of a family as provided for in Article 1163. Unsa man ang good father of the family, gidiscuss na nato ni atong prelim. Hence, S has the obligation to feed the horse and provide it with adequate shelter before the appointed delivery date, even if nothing is said about the obligation in his contract with B, as this is in keeping with good faith, usage, and law. Sa ingon, contracts must be complied with in good faith. Let us now go to relativity under Article 13.11. Sa ingon, contracts take effect only between parties. A contract can only obligate the parties who entered into it or their successors who assume their responsibility. So kung si A ug si B lang ang parties to the contract, dili pwede nga si C i-appeal ninyo kung magdemandahay na mo. It can neither favor nor prejudice third persons. Dili pwede nga hatagan ninyo pabor si C since C is not part of the contract. Kinsa lang ang parties sa contract? Si A ug si B. Now, si A namatay. Si A na itagapagmana. Ang tagapagmana ang tawag ana sa ila heirs. Heir shall not be liable beyond the value of the property he received from the decedent. Kinsay decedent katong namatay. For example, si A nangutang kag B og 500,000. Karon si A namatay. Si A na ay property nga 400,000 lang. Ang iyang tagapagmana karon, kailangan ba taplan niya ang kulang nga 100,000 nga utang ni A nga tukang B? Dili nga naman. Heir shall not be liable beyond the value of the property he received from the decedent. So kung ang iyang naman na is 400,000 lang, ang utang ni A nga tukang B is 500,000, dili obliged nga mutapal ang tagapagmana sa 100,000 kay mauraman ang value sa property sa namatay nga si A. Kung sa ingon sa relativity of contracts, under the principle of relativity of contracts, it is stated that contracts take effect only between the parties, their assigns, and their heirs. This means that only the parties, their assigns, and heirs can have rights and obligations under the contract. Strangers, mga taong sawsawera way appeal, strangers to a contract cannot be made liable for damages under the contract. Neither can strangers claim benefits under the contract. Example, we have here B and S. Unsay situation? On January 5, 2012, S promised to sell his BMW car to B for 2 million. Kano sa i-deliver ang car? The delivery of the car and payment of the purchase price was set on January 15, 2012. Kano sa sila nagkasinabot nga ibaligya January 5. Kano sa daw bayaran January 15. So on January 15, gi-deliver ni S ang iyang car. S delivered the car to B, pero si B pila gibayad? Pila gani ang value sa car? 2 million. Pero pilang gibayad ni B? 1.5. So matotal si B na ikulang nga 500,000. B promised to deliver the balance of the purchase price to S the following day. Pero B, however, failed to pay despite repeated demands from S. Pilay balance si B? 500,000. Nakabayad si B? Wala. When M, kinsa si M? Mama ni S. When M, the mother of S, heard about what happened, ni-file si mother karon. Mother filed a case against B in court for the collection of the balance of 500,000. Question, will the action for collection filed by M against B prosper? Let us go back. Kung sa itong relativity of contracts, ang parties lang ang naay right to demand ug naay right to perform the obligation. Kinsay parties nato diri? Si B ug si S. Karon ang mama ni S nakabalo nga wa day bayari ni B si S. Si M karon ang nidemanda, si mother nga sawsawera ang nidemanda ngadto kang B sa court. Will the action for collection filed by M against B prosper? The answer is no nga naman. M has no legal standing to file the action for collection against B. Under the principle of relativity of contracts, the contract takes effect only between parties. Masking pag si M, mother siya ni S, M is a stranger to the contract of sale between S and B. Hence, M cannot claim any rights under the contract by collecting the balance of the purchase price which B failed to pay. Only S is a proper party to file the collection case against B. Hinumdumi ni nga example.